of Northeast Ohio, specifically Dr. James Pontu, dated January 6, 2026, finding that the defendant is competent to proceed in this matter. And secondly, we are here is the state's understanding that the defendant is prepared to waive indictment and plead guilty by way of information to 2 counts. First count being attempted domestic violence, a felony.
If it's skipping, just to let you know, it's not my camera, it's the actual video itself is like skipping. So I'm hoping that's not like this throughout the entire video, but for right now, I mean, you can see it's like skipping as it going through, just to let you know.
Of the 4th degree, and the second count of the information would be criminal damaging or endangering, a misdemeanor of the 2nd degree. There is no agreement with regard to sentence. The state would ask for a pre-sentence investigation report, a victim impact statement, and a drug and alcohol evaluation. Thank you, Your Honor. Oh, and I'm sorry, the state does stipulate to the report.
Ms. Novotny, as to the report.
Your Honor, as to the report, defense counsel would stipulate to the report after meeting with Mr. Fisher regarding his case and ultimately discussing the nature of the report. Additionally, Your Honor, prior to coming into court, we did go over the waiver of indictment as well as the written plea of guilty previously before coming into court today, as well as conversations in the jail regarding such. At this time, Mr. Fisher would like to accept that information offer, would like to plead guilty at this time. And Your Honor, at a later event in this hearing, we would like to discuss bond.
All right, I'm going to find, based on the stipulation of counsel and the report, Dr. Pontu, that Mr. Fisher is capable of understanding the nature and objectives of proceeding against him and to participate in his defense, so I'll find that he's competent to stand trial.
Your Honor?
Yeah.
Is there any hearing impaired or device that he could use? He is on and off able to hear at this time. You informed me of.
Will you find out from Bob where that stuff is kept?
All right, try your mic now, because it should be a bit louder.
Well, I can, Jesus
You hear
Christ.
that?
Yeah, I can hear.
All right, can you Jesus Christ almighty, can you contact Patrick and Debbie and find out, we need to get, what are we gonna do when we have these folks that can't hear? We need to get something based on this system.
Yes. I'll do it.
All right. Mr. Fisher, how old are you?
66,
How far did you go through school?
a little college,
Are you a U.S. citizen?
yes,
Are you able to read, write, and understand the English language?
yes,
Prior to coming to court, have you taken any drugs or alcohol or any prescription medication in the last 48 hours?
yes.
What have you taken?
The medication that they give me in jail, do you need to know?
What kind, is it narcotic medication?
The only narcotic I take is Percocet,
All
10
right,
milligrams.
when did you last take it?
What time is it? About
Today?
a half hour ago?
All right, does it affect your ability to understand what's going on?
No.
All right, it's my understanding you're going to plead guilty to attempted domestic violence, a felony of the 4th degree. Is that your understanding?
Correct.
Do you understand you have a right to have your case presented to the grand jury for them to decide whether or not to indict you?
Yes,
Did you discuss that right with your attorney?
yes,
Are you going to waive that right?
yes.
Remember the waiver? You need your signature right there. Thank you. Your Honor, in open court, myself and my client signed the waiver of indictment and passed it to the prosecutor. The witness is saying.
Your Honor, I have the waiver of indictment that has been signed by the defendant in open court and signed by Ms. Novotny and myself.
All right, I'll accept the waiver of indictment. Now, before I accept your guilty plea, I need to determine that you know and understand the constitutional rights you'll be waiving, the consequences of your guilty plea, and the maximum penalty I could give you. And I need to be satisfied that your guilty plea is being made freely, knowingly, and voluntarily. So I'm going to ask you questions. If you don't understand the question, then stop me. If you want to talk some more to Ms. Novotny, let me know and I'll give you more time. Do you understand that?
Yes,
You have a constitutional right to have a trial, either to me or to a jury of 12 Lake County citizens. Do you understand that right?
yes,
Are you waiving that right?
yes,
If you go to a jury trial, all 12 members must agree to a guilty verdict before you can be found guilty. Do you understand that right?
yes,
Are you waiving that right?
yes,
If you go to trial, the prosecutor will call witnesses to testify against you. Do you understand the prosecutor must prove you guilty beyond a reasonable doubt at trial?
yes,
After the witnesses are done testifying for the prosecutor, you have the constitutional right to have your lawyer cross-examine the witnesses. Do you understand that right?
yes,
Are you waiving that right?
yes,
If you go to trial, you have the right to have witnesses come here and testify for you. Do you understand that right?
yes,
If you plead guilty today, you will not have the right to appeal the guilty finding. Do you understand that?
yes,
Do you have any question about any of these rights?
no,
Do you still want to plead guilty to this charge?
yes,
Do you understand by pleading guilty, you're fully admitting your guilt to the charge?
yes,
Do you understand by pleading guilty to this felony that you're voluntarily giving up your freedom for whatever period of time I could sentence you to prison, to jail, or to community control?
If I'm not mistaken, I don't want to take too much of your time, but if I'm not mistaken, the woman that's in the front typing, isn't her job is to type everything that he says plus like the judge say plus the defendant or plaintiff, whoever, lawyer, attorney, whoever the case may be, she had to type in everything that they say. Like I that's a lot of work. I hope she getting paid. I hope she getting paid. That's a lot of work to do. Because you gotta listen everything that the judge says, you gotta type it out. And then if someone intervenes or speak up or something like that, you gotta type in there what you're coming. I'm pretty sure she had to put the judge something, said da 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 da. Oh, plaintiff said da 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 da. His attorney said da da da. Judge said this da da da. Then you know what I mean. You gotta go back and forth. I feel like that's a pain in the ass to do, but shoot, hopefully she getting paid. I mean, shoot, that's a lot of
yes,
work.
The attempted domestic violence is a felony of the fourth degree. It carries an 18-month maximum prison sentence and a $5,000 maximum fine. Do you understand that?
yes,
Are you on post-release control right now to the parole authority?
no,
Do you understand that your felony conviction will prevent you from owning or possessing a firearm?
yes,
Do you understand if a prison term is imposed in this case, you might have to serve a period of post-release control for up to 2 years under the parole authority?
yes,
If you are placed on post-release control and violate any conditions, the parole authority could send you to prison for up to 9 months for each violation, up to 1/2 of my sentence. Do you understand that?
yes,
If that violation is a new felony, you could get an additional consecutive prison sentence for the violation. Do you understand that?
yes,
If that were the case, the maximum prison sentence for the violation would be the greater of 12 months of the time left under post-release control. Do you understand that?
yes,
All right, I neglected to address count 2 with you. That's criminal damaging or endangering. It's a misdemeanor of the second degree, and that carries a maximum jail sentence of 90 days and a maximum fine of $750. Do you understand that?
yes,
If I gave you a consecutive sentence in this case, one count after another, then the maximum sentence would be 18 months in prison and the maximum fine $5,750. Do you understand that?
yes,
Do you understand if a prison term is imposed, you are eligible for judicial release?
yes,
I could place you on community control for up to 5 years, but if you violate any conditions, I could send you to prison for 18 months. Do you understand that?
yes,
Has anybody promised you that I would be lenient on you just because you're pleading guilty today?
no,
Has anybody promised you what I will sentence you to in this case?
no,
Do you understand I do not have to follow the sentencing recommendation of either the prosecutor or your lawyer?
yes,
Have you had enough time to talk to Ms. Novotny before pleading guilty today?
yes,
Has she discussed everything about your case and answered all of your questions?
yes,
Are you satisfied with the advice she has given you?
yes,
Have you been threatened or coerced in any way to plead guilty today?
no,
Are you freely, knowingly, and voluntarily entering your guilty plea?
yes,
Do you have any questions at this point?
no,
Ms. Himalayan, if the case went to trial, what would the evidence show?
Thank you, Your Honor. Had this matter proceeded to trial, the state would establish beyond a reasonable doubt that on October 28th, 2025, in the city of Willoughby, Lake County, Ohio, the defendant did purposely or knowingly and with sufficient culpability for commission of the offense of domestic violence engage in conduct that, if successful, would constitute or result in the offense of domestic violence, in that he did knowingly or cause or attempt to cause physical harm to his wife, Loretta LaRich Fisher, a family or household member, by striking her. The defendant does have previous convictions for domestic violence, those being in Cuyahoga County Common Pleas Court, case number CR-12-567126-A, dated September 28, 2012. Another case in Cuyahoga County Common Pleas Court, case number CR-12-562331-A, dated September 26, 2012. And in the Lake County Common Pleas Court, case number 18-CR-000882, dated January 11th, 2019. Additionally, on or about October 30th, 2025, in the city of Willoughby, Lake County, Ohio, the defendant did knowingly cause or create a substantial risk of physical harm to two urns owned by Loretta LaRich Fisher that contained the ashes of her deceased child. By throwing them out the front door, they broke on the concrete driveway, and then the defendant subsequently took a leaf blower and blew the ashes about the yard. Thank you, Your Honor.
Ms. Novotny, anything to add to those facts?
No, Your Honor, not at this time.
Mr. Fisher, did you hear what Ms. Himmeline said, that the facts would show if the case went to trial?
Yes.
Are those facts true?
Yes.
All right, what is your plea to count one, attempted domestic violence, a felony 4?
Guilty.
What is your plea to count 2, criminal damaging or endangering, a misdemeanor 2?
Guilty.
Ms. Novotny?
This document.
You know, have them initial on page 2 where I put the meds in there,
Yes, Your Honor.
in the margin.
Would you like me to initial as well?
Sure.
Where it says Percocet, so he's informing that, okay?
Oh,
So initial right by it in the margin.
right here?
Right here. Just initial. Thank you. And I'll give it back to you in a second. And then signing, date.
It's the 14th, right?
It is 1/14/26. And then your name right there. Thank you.
Yeah. Well, thank you.
Your Honor, in open court, my client and myself signed the written plea of guilty and initialed, and then passed to the prosecutor to do the same.
Your Honor, I have the written plea of guilty and judgment entry that was initialed and signed by the defendant in open court. I witnessed that and have signed it.
Mr. Fisher, is this your signature on the written plea of guilty?
Yes.
Did you sign it voluntarily?
Yes.
Do you want me to accept your written plea of guilty?
Please.
I'll accept the written plea of guilty. Defendant was present when Ms. Novotny advised of all of his rights, been a knowing, intelligent, voluntary waiver. He understands the nature of the charge, the consequences of his guilty plea, and the maximum penalty. Find it to be knowing, intelligent, and voluntary, will accept his plea of guilty. Find him guilty of count 1, attempted domestic violence, felony 4. Count 2, criminal damaging and endangering, a misdemeanor 2. I'll refer this for a pre-sentence report, drug and alcohol evaluation, victim impact statement. Sentencing will be February 11, 2 o'clock. Ms. Novotny.
Your Honor, at this time, we would like to address bond.
Go ahead.
Your Honor, with regard to Mr. Fisher, He would reside, and he understands that he has no contact with his wife currently. He would reside, if released from the Lake County Jail, with his sister, Ava Riccardi. She's located 24. Your Honor, from my understanding, Mr. Fisher is diagnosed with a terminal cancer that may have spread to his bones with that respect. He has a lot of appointments that are necessary to make sure everything is ordered with his medications as well as his well-being. Recently, from my understanding, he was transported to Tri-Point. It was diagnosed with heart failure as well due to some swelling that is occurring with his legs. From that, Your Honor, he has transportation to come to and from court at that Lyndhurst address, as he would be under the care with his sister. We're just asking for any leniency with regard.
I'm starting to just let the video play, you know what I mean? And just give my thoughts at the end and not say anything, just so everyone can just watch as much as possible. They don't have to hear me talk over it. But regardless how old this man is and his cancer, his heart failure, and stuff like that, he took someone's ashes, threw them outside, and used a grass blower or a dust blower, whatever you call it. I forgot they said, and start blowing the ashes away. I'm sorry, like you have a lot of problems and stuff going on. I hope you beat cancer, but all in all, you blew someone fucking ashes away for what? Like, I'm sorry, but like no, prison you go, my guy. You're old, but prison you go. You don't do shit like that. And to have sympathy of, oh, I have all these other things going on. That wasn't going through your mind when you did that, though. Like, I'm sorry, like, you don't just throw someone ashes and you use a leaf blower or something like that and blow it away, and then you're turning around trying to get freedom a little bit by living with your sister or something like that, and not have contact with your ex-wife. Like, no, no, that's not how that shit works.
To recognizing a potential OR bond in this case. Thank you.
Ms. Himmeline?
Thank you, Your Honor. The state would oppose any bond modification in this case. The defendant does have a criminal history, most of which includes offenses of violence. He's had multiple prior domestic violence charges against his wife. He has assault on a police officer, disorderly conduct, menacing, and then has a prior conviction from this court back in 2019 and a probation violation that resulted from that conviction. The defendant has had escalating behavior against his wife due to his chronic alcoholism and medical conditions. The Willoughby Police Department were called a number of times prior to these offenses. He was making suicidal ideations and making comments that he was going to take his wife with him. So the state has concerns that if released, the defendant would pose a risk to her as well as to others.
All right, the motion is overruled. Anything further, Ms. Himmeline?
No, Your Honor.
No, Your Honor.
Yeah, as I figured. Yeah, I'm sorry. Age and health problems don't. No, you don't just you don't just say, oh, I got cancer, I got this, I got that going on, heart problems, da 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 da. My ear don't listen, my legs is fucking swollen, my fucking eyes is not eyeing, like all this other shit, and then you have a history of like domestic violence and a comment of if I go, you go with your wife. Like no, no, bro, just stay there, bro, stay there. You have to be a very special kind of guy to take ashes outside and hit it with a leaf blower. I don't care. My I won't even say worst enemy. I don't want a worst enemy, but if I had someone that was like I really wasn't fine of, I would think taking the ashes and throw 'em like someone else's they personally like, whether grandmom or whoever, ashes out and hit them with a leaf blower and be like, yeah, fuck you. Like that's stupid, man. That's stupid. And now look at you. You're make being that old, you should make great decisions. You should be fucking sitting somewhere farting and yelling at cats being on your yawn or some shit like that. Like you're in the courthouse fucking about to go to prison or like yeah, it's not worth it. But in this case, in this generation, I mean, you can do anything. I mean, apparently you can have sex in court. So, see y'all in the next one. Peace.